So in a private complaint, how will it work?
It must go through this first.
No. How can it go? They go to the police first.
Yes. No, because it's not the private complaint who determines this.
No.
It will
Straight away,
determine-
200 will not spring.
Yes.
154(1), they will go to a police station. Jurisdictional police, they will not register. Then a higher officer under 154(3). Then they approach 200. In 200, where is the police officer unless it is referred to investigation?
Now, Malas, two things. The number one answer. The test is based not on private or public complaint. The test is based who's the accused. That's
No,
one way.
Accused may be anybody.
No, public servant.
Of course, if it is Prevention of Corruption Act, 17A comes only because it is public servant.
So first and foremost, this is a safeguard for a limited class of people.
True, it is public servant. Now, in this functioning, the police station, yes, police officer should seek approval, no doubt about it. In a private complaint, where police officer is not involved, police officer comes into picture only when 156(3) or 175 reference happens. Reference happens for what? For registration of a crime. If registration of crime already happens, where is the question of approval?
There, Malas,
That is why that
there, Malas, either
the police officer only should seek is a little difficult
I
to.
understand, but there, if that is the case in a private, well, but then the private complaint example can't take over all the non-private complaint cases. That's answer number one.
No.
The Lordship will not read it
In a non-private complaint, obviously it will happen by a police officer.
No, but
Approval will be sought by a police
then
officer.
your Lordship, even in that category, is giving the possibility that it can be somebody else altogether. That can't be the law. But second answer, Malas, then in that case, the magistrate will have to iron out the problem.
No. That is why in that judgment, what I wrote was, in a private complaint, you are taking away the 17A approval and directly getting the crime registered. That protective filter goes away. It is rendered odious or rendered redundant.
Yes.
For that reason, whoever approaches the magistrate who would wanting to register a crime against a public servant, it is his responsibility to get an approval. Without the approval, the crime cannot, no reference can be made under 156(3) is what I have said. Their police officer comes only after 156(3).
What my Lord is
How
saying is that
do you harmonize the two now?
my Lord is right. The Act is not thought of this problem. They should have, but Malas, 156(3), should it not be coming after 17A stage, Malas?
Yes, that is what I have written. That is exactly what I have written.
No, Malas,
Kindly consider this. If this interpretation is given, will the protection given under 17A still continue to be available to a public servant? If you allow anybody and everybody to walk in and seek protection?
No. That is exactly why 17A is made applicable to private complaints also. See, now imagine a hypothetical circumstance that 17A, one complaint is registered before the Lokayukta. The Lokayukta police will seek approval of the competent authority under 17A and try to invest and register FIR, begin investigation. Now that procedure will be obviated. Ultimately, what the complainants would want, registration of a crime against a public servant. Now 17A is a bar. If private complaint is a stranger or citizen, any criminal law can be set into motion by anybody. So they go before the magistrate, register a complaint under under section 200 for various offences, including PC Act. Now straight away reference is made for it is referred to the Lokayukta. FIR is registered, investigation commences. Where is 17A? The very purpose of 17A is lost. That is the reason private complaint also.
the other, this is of course, if I may say, the casus omissus possibly in the Act also.
Casus omissus, yes.
That's not your Lordship's problem, that's not my problem.
Yes, that is the legislature. That's the.
Well, is it possible to say that the 156(3) must come and then you go through 17A after that? Because 156(3) brings in the magistrate. And then well as the private complaint goes on. But then before you proceed further, the 17A approval comes. That's another way of looking at it. I'm just thinking.
That can also be done. But prior to beginning of investigation against a public servant, 17A compliance is mandatory. That is what exactly I've said. Because what used to happen in so many cases is, they don't go before the Lokayukta, they don't go before the police. Straight away register a private complaint. And once it is referred for investigation, the police have no jurisdiction except to register the crime.
Nullifying 17A.
So defying 17A.
Fact, question of locus did not arise either in Dr.
No,
Ashok's
locus is alien to criminal law, sir.
apply under
A
17
locus to apply, locus to apply is,
arise either in Dr.
No,
Ashok.
locus to apply would, locus would become applicable to the person who wants the complaint to be registered. Now the police officer wants to investigate, he will seek, that is under the act. Now the complainant wants a private complaint to be registered against a public servant for offences under the PC Act, he will seek.
So there is a problem. The only thing I can think of is that there is a 156(3) going to the magistrate and some procedure of 17A follows that. That's one way of looking at it, Malus, but.
We'll try to harmonize in this case.
Anyway, your lordship is good, Malus, because
Yes.
if 156(3) goes first and 17A follows, your lordship is having fidelity to both. That's what I was just trying to think out. But there may be some other problem I'm not able to think out immediately, Malus.
No, why I wrote that order was, I'm trying to, otherwise 17A becomes.
The lordship may consider this, that your lordships should preserve the primary filter of the police officer. One way of preserving it is to have the 17A cases in a private complaint go through the filter, of course, as it does through a 156(3), followed by the requirement to get a 17A.
Well, accept that. Now, in a given case, 17A approval will be sought. For what? It may not proceed further.
No, but Malus, your lordship is only concerned with the approval being sought and going through a police officer's filter. It may
That's
not
what,
be
whether
given
it is the
except when
police officer or the person who sets the criminal law into motion.
Malus, it can be with 156(3), there is some greater harmony as I see it here, Malus. Any magistrate may order an investigation in
Yes.
156(3).
Order an investigation.
But Malus, if 17A has to have meaning, then why?
No,
can't
now against a public servant also, a magistrate can order investigation.
But then, exactly. But then, because he's a public servant.
17A should be there.
Exactly.
That's exactly what I've written.
But Malus, after the entry of 156(3),
29.5.
Malus, I have tried to answer it somewhere lower down, Malus, but let me just read through it. These are the only two answers, Malus. The harmony can be that your lordship does not render a 17A to be
No,
diluted.
the language in 17A is no police officer shall commence inquiry or investigation. Fair enough.
All three covered. All three are covered.
All three, no problem. No police officer can commence without prior approval under this provision by the competent authority.
Technical sense, the magistrate.
Who seeks the approval is not there in the statute.
That is a separate matter, Malus. Whether locus is not there, criminal law has locus or not, all that is separate. My point is, whoever it is, let's say assume a stranger is there. Your lordship gives a definitive role to the police officer. The first port of call is a magistrate who is not a police officer. He initiates or allows their filter of 156(3). The second port of call must be a 17A police officer. And then, Malus, that man, if we say no,
Now
then the locus ends of that
Now
chapter.
156(3), magistrate refers. Will the police officer who has been directed to conduct investigation wait for an approval from the competent authority?
No, that's then Malus, the answer is clear. Once your lordship accepts that, answer is yes, he has to. Otherwise, Malus,
that
what's
is
the point of
why-
having 17A, Malus? Then your
That is why, to obviate that procedure of once referring the matter for investigation and registering the crime, so taking 17A approval for conduct of investigation. If a prior approval is already there, magistrate will refer it and the investigation will commence immediately.
that will, Malus,
That is what
I understand, Malus, your
yes.
lordship may consider harmonizing in this way because that
is-
means that the primary port of call of the police officer is ended or diluted. That is my problem. I'm trying to harmonize that part. In this other model I am giving a lordship, which is not Malus, fully thought out, maybe I can give a supplementary one-page note after thinking it out. It appears prima facie that your lordship does not violate any of the provisions of the statute.
That's
Because
all.
the outsider chap, Malus, goes to the magistrate, he gets some order.
Yes.
Then, Malus, it must fully satisfy the police officer who will say no. That's the end of the story as far as he's concerned with that point.
No, he has
That
no
point.
jurisdiction to say no once the magistrate refers the matter for investigation. The investigating agency cannot say, I will not investigate.
That's the point.
That is why that protective layer should
Right, no,
spring
my lord,
prior
right.
to the complaint.
Therefore, your lordship judgment will have to say that the 156(3) order cannot violate a 17A order. Your lordship will have to say that a 156(3) order must then thereafter.
Cannot violate a 17A order.
No, not
True.
cannot violate. must not override the 17A order coming later. This 153 will say, I'm referring it, but this part will be done first, 17A. PC Act. Because this was, in fact, the more
PC
we
Act, of
discuss
course,
it,
yes.
it's becoming partly clearer. Your lordship is having a limited class. It is not except outside the PC Act and public servant. For that limited class, suppose the magistrate says, he will not say it generally, he'll only say it under your lordship's orders. Otherwise, High Court has to lay down the law. That, look, I am issuing a direction, I'm initiating this investigation, but where 17A is required, it will proceed further only after 17A is given or not given.
So now magistrate refers under 156(3).
But then comes
The
17A.
jurisdictional police or the locaयुct at whom it is referred, he may have to wait for 2 months, 3 months for approval and then begin.
That is one way of looking at it.
And then begin. Is it not that if the approval is already there and a private complaint is preferred, reference be made prior to approval, is not a better circumstance?
Then your lordship is bypass the police
No,
officers
we are only permitting police officer only to investigate. Nobody else is investigating. After reference, only the jurisdictional police or the locaयुct will investigate. But he will investigate only after the approval is there under